I am not an attorney and no part of this video should be considered legal advice. This is an RF 401 or a purchase and sale agreement for real estate in the state of Tennessee. So on line 3, you have the buyer or the buyer's names. Line 4 would have you, the seller, or the seller's names. And then in line 6, it goes into the legal description of the property. Line 12 under A, it starts to talk about all the things that will be included with the property, such as light bulbs and light fixtures, window blinds, mirrors, curtains, all of that sort of thing. And it has a blank there on line 17 where if you have a garage door opener with remotes, how many remotes you will be leaving with the property. Line B under line 23 talks about other items that remain with the property at no additional cost to the buyer. So buyers need to be very careful here. So if there's a shed in the backyard or something along those lines, it could be moved. It may not be easily moved, but could be moved. You would want to put that in the blank there. But you could also put appliances, furniture, trampolines, swimming pools, hot tubs. Just if there's anything at the property that you would like to keep, you would put it in the blank there under B. Line C, items that shall not remain with the property. Typically, what I have there is any personal items of the seller. The seller could then leave what they want to or take what they don't. Stuff along that line, unless it's specifically mentioned up on line B. Line D talks about leased items. If you, the seller, have any leased items on the property, what are they? And then the checkbox on line 33, the buyer would check that box if they do not wish to assume the lease of any items. And then underneath it says buyer does not wish to assume seller's current lease of, and then you would type in there whatever the seller has leased that is on the property. Line 38, number 2, that's where we get into the important part of this. At least on the seller side of it, this is what you're looking for. This is where they talk about how much they are offering for the property. So on line 40 and that blank there beside the dollar sign, that would have a number amount. It could be $1 million, $5 million, $5,000, $100,000, $150,000. This is what the buyer is offering to pay for your property. Line 46A, this is a financial contingency talking about how the buyer has the right to assume a loan for the property and how much percentage there on line 47 will the buyer be borrowing. That could be 80% is a popular number there. 0% is a popular number there if the buyer is intending to pay cash for the property. 96.5% is there, and 100%. Those are all popular numbers, but you can see 50%, 75%, 90%, just whatever percent number that the buyer is going to borrow to purchase the property will be in that line there on number 47. Line 49 down to 58, it talks about how the buyer will be purchasing the property. They would check the box beside whichever type of mortgage they're going to use, whether it be conventional loan, a VA loan, an FHA loan, rural development loan, or other. You could check that box for other. Typically, if I have a cash buyer, I click the box for other, and then I would write in cash there beside it. Line 63 there says loan obligation. The buyer agrees and or certifies as follow, which it talks about the buyer has 3 days to apply for a loan and get approved for a loan after the agreement of this. Typically, I always want the buyer to be pre-approved and ready to go before I sell them any of my properties or ask my seller to accept the offer. That way we're not taking the property off the market for someone who may not even get approved. So we go ahead and send them to a mortgage lender and see what they can do. And then once they're approved, we let them put the offer in. But if they want to make the offer, which we have to, notify our sellers, hey, so-and-so is offering $200,000 for our property. Do you want to take it or not? They're not approved for a loan yet. Would you rather them go ahead and get approved and then submit the offer? Ball's in your court. We can take it and give them 3 days to get approved, or we can ask them to go ahead and get approved and then come back with their offer. Typically, the seller always wants the buyer to be pre-approved before making the offer on the property or before accepting the offer on the property. Line 85B here, you would check this box if the buyer is paying cash. This is the financing contingency waived. And then in the blank there on line 88, you would type in how is the seller going to prove they have the funds to pay for this property, whether it be a bank statement or a lender's letter or whatever the case may be of how the buyer intends to let the seller know they have the proof of the funds available to purchase the property. Line C, number 1, this agreement is not contingent upon an appraisal. Now, if the buyer is getting a mortgage, it will always be contingent upon an appraisal, which would be number 2 that you see on the bottom of your screen there. But if someone is buying the property with cash, most of the time they're not going to get an appraisal. They could just for their own peace of mind, but most of the time if someone's paying cash, at least in my area, they don't get an appraisal. But if the buyer is getting a mortgage on the property on line 102, this agreement is contingent upon an appraisal, and that box would be checked there. Line 117D, it goes in to start talking about closing expenses. Line 127 in big bold letters, it says, in the event seller is subject to tax withholdings as required by the Foreign Investment in Real Property Act, Tax Act, seller additionally agrees that such tax withholdings must be collected from seller by buyer's closing agent at time of closing. And then line 131, it goes on to say, it is seller's responsibility to seek independent tax advice or counsel prior to the closing date regarding such tax matters. And then line 142, number 3, it talks about the title expenses, closing cost is what most people call it. But in that line there below on line 144 is what you would type in there if the buyer were asking the seller to pay closing costs or title expenses. So typically that line could say seller to pay up to $5,000 in buyer's title expenses and closing fees. It could say seller to pay $20,000 in buyer's closing costs and title expenses. Just whatever that number is, or if each party wants to pay for their own closing costs, title expenses, and fees, that would say seller and buyer to pay their own closing costs and title expenses. Now on line 150, if the buyer is asking the seller to pay some of their title fees, closing expenses, you could break that down there into that box. That way you're only helping pay for the buyer to, certain fees. So maybe it's attorney fees, prorated taxes, just whatever closing fees or title expenses that you're helping the buyer to pay for, that could be lined out there on 151 in that box there. Line 155, it talks about the closing agencies, who is going to be closing the transaction. In my area, most of the time the buyer and the seller have the same closing agent. Your area could be different because it does not have to be at the same closing agency. Most of the time mine is at an attorney's office, but there are certain places that you can go that just does real estate closings and like title companies. But like I said, in my area, most of the time that is the same, but you do not have to use the same closing agency for the buyer and the seller. In my experience, that's just quite a bit easier. Line 159 talks about the earnest money. How long does the buyer have to pay that earnest money? Who's going to hold the earnest money? Where is the person holding it located at? How much are you going to be paying in earnest money, and how are you going to be paying it, whether it be a money order, cashier's check, personal check, whatever. All of that would be written there in those blanks. Line 190, number 4, this is your closing day. This is the day that the property is going to be transferred from the buyer to the seller. And in the blank there on 193, the date that you intend to close would be entered in right there. On line 197, it talks about possession of the property. You would check the box either on line 199 or the box on line 201. 199, the possession will be transferred to the buyer at closing, evidenced by delivery of warranty deed and payment of purchase price, or as an agreed upon, attached, and incorporated temporary occupancy agreement. So if you, the seller, got your next place lined up, but it may be 2 weeks, 30 days, 2 months, whatever the case may be, before you can move into it, and the buyer has agreed to let you stay in the property until your next place is ready, that box will be checked there, and there'll be another document talking about all of that. That's a very rare thing. I don't know if I've ever seen that done. I've had it talked about before, but I'm not for sure if any of our properties have ever actually done a temporary occupancy agreement. 208 line C talks about the greenbelt, whether the buyer intends to keep the property in the greenbelt or not. That you won't find that in like neighborhoods or subdivisions most of the time. That's like on your farms and things like that. It's like a tax type of deal for properties that are 15 or more acres. Line 218D, special assessments. It says special assessments approved or levied prior to the closing date shall be paid by the seller at or prior to closing unless otherwise agreed upon as followed. And whatever those terms are, you would enter it there in the box below on line 220. 255C, this is the deed. In that blank there, you would enter the names that are going to be recorded on the new deed. Typically, the closing attorney will verify that at the closing table. At least the one that I typically use most of the time does. He always asks, is this how you want your name to appear on the deed? Is everything spelled correctly? And the buyer will say yes or no, and they would make adjustments if it were ever messed up. Line 271 talks about the lead-based paint disclosure. So if the property was built after 1978, you would check the box that it does not apply. If the property was built in 1978 or before, you would check the box that it does apply, and the lead-based paint disclosure would be attached to this document as well. 273, number 8, it talks about inspections and all the things that the buyer is allowed to inspect. Talks about home inspections, pest inspections, utility inspections, all of that. D, buyer's inspection and resolution. That little blank there, you would enter in how many days the buyer has the right to inspect the property. Typically, that's 14 days or 10 days. If you're dealing with someone outside of a real estate agent, that could be all the way up to the day before the closing. So you always want to be careful with the inspection period because you don't want someone to get you in a contract with your property. You can't market the property to anyone else. You can't deal with anyone else. They run the property all the way up to the day before closing, and then I'm going to send an inspector out there. I changed my mind. I don't want the property anymore. And then they'll walk away for any reason. So we don't want that happening. So we want to really limit their time on when they can get an inspection. We don't want to withhold the inspection for them. We want them to get the inspection. We want everybody to be happy after the transaction is over, but we do not want to be taken advantage of as well. On line 307, it says in big bold letters, in the event buyer fails to timely make such inspections and respond within said time frame as described herein, the buyer shall have forfeited any rights provided under this section 8, and in such case shall accept the property in its current condition, normal wear and tear expected. Line 322, it talks about after the buyer has an inspection, say something pops up on the inspection report and they're either going to ask for repairs or ask for a cheaper price. That little blank there would be how many days you have to come to a new agreement, whether that be 2 days, 3 days, 5 days, a week, 2 weeks, whatever would be entered in that box there for you to renegotiate the deal and come to a new agreement. Or the buyer could just walk away altogether within that time frame. So typically I always put 3 days in that time box, but any number could be put in there. Line 343E, this is the waiver of inspections. If the buyer does not want to have any inspections done on the property, typically, again, cash buyers, they may or may not get an inspection done on the property. Anybody getting a mortgage 9 times out of 10 is always going to get an inspection done. But if they want to waive their right to do the inspection on the property, there is a checkbox that you would check there. 352, number 10, this is the final inspection period. So this is how many days before the closing that the buyer gets to walk through the property and make sure nothing has changed since the last time they've seen it. Typically, that'll be 1 or 2 days, but again, that could be a week, it could be 10 days, it could be 3 weeks. Just whatever the buyer puts in that box is how many days they have to walk through the property to make sure nothing has changed or been damaged or whatever before actually closing on the property. Line 418, number 15, this is the home warranty section again. This is where if the buyer is going to ask for a home warranty, they would check the box there, talk about which plan they want, how much it costs, who's going to pay for it, which company is ordering it, and then line 423, if the buyer does not ask for a home warranty, they would check that box. Line 424, number 16, this is non-assignability of contract. So wholesalers, this contract cannot be sold like a wholesaler would typically sell a contract. It says this purchase and sale agreement shall not be assignable by the buyer without prior written consent by the seller. So if the buyer wishes to assign this contract to someone else, they can, but the seller has to sign off on it, allowing them to have that right. Line 498, number 20, exhibits and addenda. Most commonly, this is where if you were purchasing a separate parcel of land with the property, so say the house sits on one parcel and the land sits on another neighboring it, you would enter in the legal description on all of that of the second parcel that's going to be included with this property. Line 503, number 21, this is special stipulations. So if anything wasn't mentioned above, you could type it into this box here. So say on your initial walkthrough, if you notice repairs that needed to be made without even having an inspection done, such as a broken window or a mirror or a sink faucet tore off, just whatever it is, you could type in seller to repair whatever repair you may need here. And then another thing that's popular in the special stipulations is say you're buying the property, but you need another property to sell before you can purchase this property, you would type in here, this offer is contingent upon the successful closing of XYZ property on XYZ day. And then on line 515, number 22, this is a limited offer. So this offer will expire and you enter in the day and time that this offer will no longer be good. So if the buyer walked through the property and seen it on Friday, and they want the seller to give them an answer by Monday, then they would type in Monday's date at whatever time on Monday that they wanted an answer by. This is mostly so buyers can window shop or look at other properties. They're not held up sitting here waiting on this property to close. But this is also so you as the seller is not collecting a bunch of offers and then making them bid against one another. Typically, what I recommend my sellers to do is, hey, this offer is good for 2 days, 3 days, a day, whatever. Let me push this property really hard and see if I can get us another offer, which is my strategy that I try to do. And then if we get another offer, we have the option of either going with the best one or going back to the lower offer and telling them we have a better offer and see if they can do any better and kind of just, work it up until we can get the best deal. But the buyers don't want us to do that. So they want to make these offers, as short as possible, but within a reasonable amount of time for the seller to consider the offer as well. So typically 24 or 48 hours is usually what I see these offers to be good for. Line 517 in big bold letters, it says legal documents. This is an important legal document creating valuable rights and obligations. If you have any questions about it, you should review it with your attorney. Neither the broker nor any agent or facilitator is authorized or qualified to give you any advice about the advisability or legal effect of this provision. 520, again in big black bold letters, it says, note, any provisions in this agreement which are preceded by a box must be marked to be part of this agreement. Any blank herein that is not otherwise completed shall be deemed to be zero or not applicable. Then line 522, talks about wire fraud. Basically, no one is going to be asking you for money. Never accept wiring instructions from your agent or broker, which, we would never do that. At least where I'm at, we would never ask you to wire us any kind of money. By fixing your signature below, you acknowledge that you have reviewed and understand all terms of this agreement. So the buyer would sign there on line 528 and date when they've signed, and then it would be sent to you, the seller, and you would have the option to check the box of accept. If this offer was great and included everything that you wanted, you would check the box for accept and then sign on line 536. If the offer was terrible and you didn't like anything about it and you can't believe they would even send it to you, you find it as an insult, you would check the box on line 535 as reject and sign and date below. But say, the offer is closed, but it's not exactly what you're looking for, you would check the box on line 534 as counter, which I'm about to show you the counter offer sheet. You would sign and date it and then send it back to the buyer. And then acknowledgement of receipt on 540. This is where either the buyer's agent or the listing agent, one of the two, would sign here below, binding this agreement, making it, it's binded, it's ready to go. So say the offer was closed, but not exactly what you're looking for. You could check the box that says counter and send the counter offer back to the buyer. So at the very top, it would ask what number counter offer this is, and this would be counter offer 1. On line 1, it asks, is this from the seller to the buyer or the buyer to the seller? Then you would have the seller's name and the buyer's name, the date of the offer, and then the property address, and they're on line 6. Now on line 9, this is the box that you would type in any counters that you have. But remember, if it's not mentioned on this document, that means you agree to that on the offer. So the only thing that changes from the offer is what is written on this document here, the RF 651, the counter offer. So say someone offered you $150,000 for your property. You wanted 175, but you would take a little less. You may counter back on this document saying purchase price to be 170. Just whatever number that you would be happy with, you would enter it on this document. But there's more things to negotiate than just the purchase price. You could send a counter offer back. Maybe the buyer offered to pay $500 in earnest money, but you don't think that's enough to keep them serious, so you counter back and write earnest money to be $2,000. Maybe the buyer asked for a 30-day inspection period in the offer. You believe that is way too long, so you counter back and say inspection period to be 10 days, 14 days, 7 days, just whatever number that you find acceptable. And you can enter multiple things on this counter offer. So you could say purchase price to be $10,000 more, and then you could skip a line and say earnest money to be $500 more, and then you could skip a line and say inspection period to be 1 week less. But you want to be specific with it. Inspection period to be 10 days, purchase price to be $170,000, earnest money to be $1,000. You want to be specific with it, and then you would sign it, date it, and then send it back to the buyer. And now the ball would be in the buyer's court to accept or reject this counter offer. Maybe the buyer is happy with everything that you wrote on this counter offer and they will accept it. Maybe the buyer says, okay, my offer was all that I can do and I can't do any more, so I'm going to reject it. Or maybe the buyer thinks that this is pretty close, so they check the box for counter, and then obviously they would sign it, and they may send a counter offer, and then their counter offer may be counter number 2. That's what it would say. And then the box on line would be checked buyer to seller. So again, anything that was on the previous document that is not on this document would be agreed upon. So say you sent all 3 of those line items to the buyer for as far as purchase price to be 170, inspection period to be 14 days instead of 30, and earnest money to be 1,000 instead of 5. Well, the buyer says, okay, I'm good with a 14-day inspection period, so they just leave this off of this counter offer number 2. They're good with paying $1,000 in earnest money, so they leave this off of counter offer number 2. They send an offer back and says purchase price to be $165,000. So everything that was mentioned in the previous counter has been accepted, so it's not mentioned on this counter. The one thing that is mentioned is what they want changed. So once they send that over to you, they would sign it, and then you would have the option to accept, reject, or counter again, and then obviously sign it and send it back to them. For instance, in this case, we just say you accepted it, so now we're good. But you could do this back and forth however many times. Just remember, if the line item is not mentioned in the new document, it's only on the previous document, that would mean that whatever was on the previous document has been agreed upon. So you've received the purchase and sale agreement, you went back and forth countering each other, and now you've finally come to an agreement. But then the inspection period begins, and the buyer gets an inspection done, and there's some things that the buyer needs to have fixed or have the seller fix, and now it's time to renegotiate that. Now, this is the repair replace amendment, so this is what makes it binding. Now, there is a repair and replace proposal, repair and replace proposal. I'm not going to show you that, but that's where the buyer and seller can go back and forth, negotiating on the repairs to be made, and then once they come to an agreement, it will be converted into an amendment. So it asks for the date of the binding agreement. So when did you come to terms on the buyer purchasing the property? And then on line 5, it asks for the address of the property. And then in the box, the big box here on line 8, this is where the buyer will ask for repairs or a new purchase price or whatever, and the seller would agree to. So say the inspection come along, and I'm just trying to think of something off the top of my head real quick that the buyer may find in an inspection report. Maybe it's exposed wires in the electrical box. Maybe it's rotted deck boards on the porch out back, a missing shingle on the roof. Once the buyer and seller come to an agreement on who's going to pay for this, maybe the seller doesn't have the money to fix these items. Maybe the seller just doesn't want to go through the headache of it. So it would just say purchase price to be say we agreed on $165,000 before, maybe the purchase price to be $160,000 in lieu of repairs, or maybe it could also say seller to have electrical box inspected and repaired by a licensed electrician, seller to have roof repaired by a licensed contractor, seller to have deck board repaired by a licensed contractor. Just whatever the buyer and the seller agree upon, it would be written on this document. And then on line 24, it says seller agrees to complete the above matters within however many days before closing. And then again, the buyer and the seller would both sign this document. And this is the last document I'll show you. This is an amendment to the purchase and sale agreement. So at the very top, it will ask what number amendment this is. So in this case, it would be amendment number 1. And if we needed another amendment before we got to closing, that would be amendment 2, and then next will be amendment 3, and then so on and so on. Hopefully we won't need any amendments, but just in case we do, we have this document. So the first one would be the buyer's name, and then the seller's name, and then line 3 would be the property address. And then in line 6, you would put the date of the binding agreement. And then again on the big box on line 8, this is where you would type in whatever changes needed to be made to the property. And this could be practically anything. So say some sort of emergency popped up and you can't make it to the closing date. A lot of times in our cases, it's the lender, the mortgage company being slow and not doing the stuff that they need to do. So we need to push the closing date back. So we change the closing date instead of like closing date to be 9/25/25 instead of 7/2/25. If we need to change the closing date, we would use this document to change the closing date. Say the appraisal come back and the appraisal came in low, which I've not had a problem with so far, but say the appraisal came in, the appraisal came low, the bank won't lend the money, whatever the reason may be. We need to change the purchase price. We would change the purchase price on this document. We could change anything in the purchase and sale agreement on this document. But remember, the only thing that changes is what's written on this document. So if it's not written on this document and it's in the purchase and sale agreement, the purchase and sale agreement is king. But if it's on this document and both parties have signed and agreed to it, then this document is king. But the only thing that changes is what's written on this document. And you can pretty much use it to change anything that you need to within reason. But again, both parties have to agree to it. And then on line 30, 31, the buyer would sign. And on line 30 and 35 and 36, the seller would sign. So anyways, guys, I hope you got some value out of this video. If you did, be sure to leave a like and subscribe. And we'll have some more home tours coming out pretty soon, and hopefully some more great real estate advice too.